Hello friends. In the last video, I have told clearly about what is law, essentials of law, and then normally the types of law or sources of law. Next, we will move further in the case of normally mercantile law or the business law. So basically, what is important is when we enter into business, normally we meet many parties, right? So when you meet many parties, there normally the parties may be of like minds or unlike minds. If the parties are of like minds, normally we straight away say that we can have a business relationship with such kind of people, because two minds should be close and two minds should have equal thoughts. Only then we can find that a business contract is possible. If not, we cannot have a business relationship with such kind of people. That is not. So in such case, normally we come across something called as a contract. So what is this contract now? So first of all, let us try to understand, because contracts today are very much common in the business. So in cities, we find that contract is given for many things. So today, when people are busy in the city of Bangalore or Hyderabad, they don't even have a time to put rangoli before their house. So rangoli is also given a contract to a particular maid who is expert and specialized. What she does is, early in the morning she wakes up, comes, put the rangoli in front of those people who have given her a contract and paid the advance amount, and then now again she goes. End of the month she is receiving the balance amount of whatever is there, unpaid advance. So in such case, normally see what happens there is a contract is possible. Second example, let us take. Today we find that normally let us come to the food industry now. When women started working, normally we can find that one of the service industry which is coming up very fast is fast food and catering industry. In the case of fast food and catering industry today, we find that even catering has become a contract today. On all type of occasions, they supply food on time. They make sure that whatever the recipe and whatever the menu which is ordered reaches the respective customers on time, and they satisfy the delicacies of the people, right? So this is one thing which is there. So this is also a contract which is taking place, where there are two parties. You observe there are two parties. The first party is the person who gives the contract, and second party is the person who accepts the contract. The first party who gives the contract is called as the contractor, and the party who undertakes the contract is called as a contractee. So it is an act between two persons, minimum two persons, and there are chances that there may be more than two persons also. It is possible in the contract. This is one side. Now let us see what legally a contract means. Contract, as per the Indian Contract Act 1872, is any agreement enforceable by law, and where the parties can put forth their promises. Parties can do their promises and act with their promises. This is basically called as a contract. Any agreement that is enforceable by law. Okay, and here we find that the contract basically is legal. Why? Because first thing is minimum parties, there must be minimum two. Second thing is it's an act to undertake and act not to undertake, which means that there are do's and don'ts observed. And third thing is the contract is legally bound, mainly because the parties form an agreement here. An agreement means anything which contains terms and condition and which is legally permissible, whichever comes within limits of law. Okay, so in such case normally we find that the contract basically is undertaken between the two parties, which is valid very much. So a contract normally should have the following terms in that. So first one is normally there must be minimum two parties. Secondly, a contract must also consist of normally a legal relationship. And third thing is this contract must be enforceable by law. Remember this, minimum two parties. Second thing is to create a legal relationship, and third thing is it must be enforced by law, not violated by law. This is the case. So this is called as a contract. A contract is always coming under Indian Contract Act 1872. So which means that it has carried before a century. More than centuries are over. Now even today we can find that a contract is in force. Today we can find that only contracts are common in business, is it not so? For example, a contract between outsourcing agency and software company is also a contract. A contract between normally HPCL and the petrol pumps is also a contract. A contract between AC manufacturer and normally the automobile manufacturer is also a contract. A contract between a banker and a recovery team is also a contract. So in such case normally we find that a contract is very much applicable in the business. So business cannot flourish without the contract. This is the stage now. So we have reached a stage where more number of activities are given for a contract outside because of one or the other reasons applicable in the business. So in such case, let us see what is required in the contract, or in other words, what are the essentials of a valid contract. So very important from your examination point of view, as well as learning point of view, as well as knowledge point of view. Okay, so let us see this now again from the legal point of view. From the legal point of view, The following should be essentials in a contract. First one is plurality of parties. Plurality of the parties means, plural means what again? Two parties, more than one parties. The parties should be more than two in number. Important condition is this: the parties should be more than two in number, and these two parties must have similar nature. Their nature must match. These two parties must have a common intention. These two parties enter legally in the contract. So in such case, now again, they trust one another, they believe one another, they respect one another, and they come together one another. So in such case, now again, a respective contract is possible. Plurality of parties means like set of minds or equal minds between two persons. Only then a contract is possible. First thing. For example, now again, see, when you look at now, the contract between an auto rickshaw driver and a passenger is also a plurality of minds. Why? Because a person says the direction, and auto driver takes him to that particular direction, which means that ultimately what happens is a destination is reached and the auto rickshaw driver will receive the fare for his service, courteous service rendered by him. So this is possible in the case of plurality of parties. Okay. Second one is offer and acceptance. Offer and acceptance. Now, first of all, let us understand what is offer. Offer is anything which has been given or anything which has been undertaken is called as an offer. Any act that is undertaken legally can be called as offer from the legal point of view. Any act undertaken legally. So in such case, now one party makes an offer, other party accepts this particular offer. Acceptance basically means assent to the offer given, or now the confirmation of the offer is called as acceptance. So offer and acceptance are just like two sides of the same coin. One party makes the offer, other party accepts the same. For example, you invite a particular resource person for a function in the college through WhatsApp message, send him an invitation through WhatsApp message. Other party accepts by giving a reply for that message, saying that whether he is going to come or he will send some other person or you just keep the function for some other day, which clearly means that now again one person making an offer, other person accepting the offer. So there is a contract between the two parties now. Okay, this is there. Next one is only intention to create legal obligation. A contract must come into force by an intention to create a legal obligation. So in such case, now what happens here is now again, when you enter into the business contract, very important thing is you should believe one another, you should trust one another, you must respect one another. So in such case, respect will be more and more careful when things are turned legal. So there must be a legal agreement to bring up this particular trust. For example, now when you open a bank account, now the bank takes the documents from us, verifies the documents like your identity proof, residential proof, photographs, signature, etc. Why? Because now is to authenticate and now again to make sure that the parties undertaking the financial contracts are clear in their transactions. The parties undertaking the financial contracts are not convicted persons, not unsound mind persons, not that those persons who are foreigners, not those persons who are convicted by the court. To make the confirmation of this, now again they come across this and the intention becomes a legal intention. No black money, no unauthorized transaction, no undeclaration of any of the wealth in the form of cash. All these things are there. So in such case, it is a clear-cut legal relation between a banker and the customer. Simple example. Now the fourth one is lawful consideration. When you speak of lawful consideration, the consideration must be very much lawful here. So in such case, now again, see the certain contracts, now whatever we undertake, now it should not be opposed by the public policy. Rather, it must be as per the interest of the public, as per the interest of the society, as per the interest of two parties. So in such case, there must not be something called as opposed by the public policy, like agreements to create monopoly, agreements in restraint of the trade, like that. So we find that there must be lawful consideration. Next one is capacities of the parties. The parties, whoever are entering into the contract, must have contractual capacity. Contractual capacity means the person should have eligibility to take the contract. Without eligibility, a contract is not possible. For example, if a candidate wants to pursue MBA in a top prestigious institution, they may say that you must qualify the respective entrance exam, whichever it is, whether it's a PG, CET or CAT or MAT. Second thing is, you should score minimum 50% in your degree marks. Suppose if the candidate is having only 49%, he is ineligible, which means that he do not have a capacity to contract. So, condition for the capacity to contract means he must fulfill the eligibility norms, only then it is possible. Next is lawful object. And the contract must be a lawful object. So, here only lawful activities should take place, not unlawful activities. For example, a house rent out for a rent, must have a rental agreement in support of that. Legal document to be support of this one is a rental agreement. A rental agreement should come out with the terms and conditions as to what is the rent, what is the advance, when the parties normally are supposed to pay the rent, what happens suppose if rent is not paid, or normally if they cause any kind of disturbances. All these conditions must be mentioned there, only then it becomes a lawful object, because owner knows his obligation, tenant also knows his obligation. This one, sir. Next, certainty of performance. So contract must be certainty of performing. So which means that normally again the parties who are entering into the contract must make sure that the contract is a valid contract. For example, normally after making a payment of normally a particular bus to the company's duty is normally to hand over the bus chassis to the owner. So which means that amount belongs to the company and the bus belongs to the owner there. So in such case, both have got a legal relationship under this. So in such case, now again what we can identify here is there is a certainty of performance. To conclude, what I can say is the contract must be between the two parties. It must be as per the regulations imposed by Indian Contract Act 1872, and it must have the following essentials as discussed earlier. Thank you very much.